For those of you who are following the Michelle Troconis trial, today was a very interesting day. It was a day that was filled with argument. Lawyers arguing with each other, and there was, of course, some evidence, some testimony that was taken, but a lot of the day was spent on argument. And while all of my viewers and subscribers were sitting there watching the arguments going back and forth with the attorneys, you were thinking, sheesh, I really hope that Brother Counsel is going to give us a video so we can unpack this all and explain it all to us to really understand what is really going on. Well, I'm not going to unpack all of the argument that went on today because there's a lot of it, but I am going to discuss, I think, one of the more exciting arguments that were made, and something that's exciting, also interesting in the law. So you've been watching the Michelle Troconis trial, and you've been watching you're going through all this DNA experts, and now the cell phone tower experts, and the vehicle experts, and it's just really, it's hard to watch. It's just a lot of boring stuff. And a lot of times in the trial, you get to hear from the medical examiner. The medical examiner is the one who performs the autopsy, gives an opinion about the cause and manner of death. So certainly that's a little bit more exciting. And that issue specifically actually came up today because the state wanted to call a medical examiner to give an opinion about Jennifer Dulos. Jennifer Dulos, as we know, her body was never found. So at the same time, you're thinking, oh, okay, well, the state's going to call a medical examiner to give us his opinion about, or her opinion about the manner and cause of death. But then you might be thinking, well, hold on a minute. There's no body here. There was no autopsy done. So what exactly is this expert supposed to say? He never performed an autopsy. And to that, the response is, well, there's a lot of evidence that he can review, or he or she can review, to come to a determination about what happened to Jennifer. He's got her clothing, after all. Remember her bra that was filled with blood, and some other evidence and some other police reports he can look at, or she can look at, to come to the conclusion of the manner and cause of death. So the state wanted to call a medical examiner. And the defense actually filed a motion in limine, and all of my viewers already know what a motion in limine is. A motion in limine is a motion that you file to keep certain pieces of evidence out of court. So the defense filed a motion in limine to keep this witness out because, of course, you have to let each side know which witnesses you intend on calling. They listed that medical examiner as an expert witness. The state listed that the medical examiner as an expert witness that they intend to call, and the defense filed a motion in limine. And today, when they're about to call the witness, the state's about to call the witness, let the judge know that they're about to call this witness. The judge said, okay, well then let's argue this motion in limine now, and that's what we were hearing in the middle of the trial today. I think it was after the lunch break, where if you want to go and go back and look at that argument, you'll see the oral argument between the defense attorney and the state, and eventually the judge's opinion. And now, after watching this, everything's going to be crystal clear, and you're going to understand everything. And you should rewatch it now that you're going to understand it all, and now everything's just going to click into place, and you'll appreciate everything a lot more. So, the ultimate question is whether this medical examiner is going to be allowed to testify. And obviously the sticking point here is that this medical examiner never performed an autopsy. So let's start from the beginning. We always have to start from the beginning to really understand everything, which is what we do here. We don't just pretend like we understand everything. We start from the beginning. And when you start from the beginning and you build it up, then you can understand everything. So let's start first with opinion testimony in the first place, because after all, that's really what an expert is there for. An expert is there not to tell you just simply what he observed or she observed. An expert is there to give you his opinion, his expert opinion. But what about a lay witness? Can a lay witness give an opinion, or is a lay witness is what we refer to as a regular old witness? Can a regular old witness give an opinion or not? So let's take a look at the Connecticut Rules of Evidence. Isn't that a good place to start? So this is Section 7-1. We'll start with Section 7-1. This entire Section 7 is dealing with opinions and expert testimony, but starts off with lay testimony. So Section 7-1 states the following. If a witness is not testifying as an expert, the witness may not testify in the form of an opinion unless the opinion is rationally based on the perception of the witness and is helpful to a clear understanding of the testimony of the witness or the determination of a fact in issue. What does that mean? Can't you just say that lay witnesses can't give any opinions? That would make things a lot more simple, right? But that's not That's how is the lawyer supposed to get paid unless we make things complicated? So when this is a little, they have to throw in some caveat here. So yeah, sometimes a lay witness is allowed to give an opinion. When would that be? So essentially what it comes down to is if it's just helpful to get a clear understanding of the testimony. Sometimes it's if you're just limited to facts and specific observations without just giving some basic opinions, it's just going to be very hard to understand what you're trying to say. So for example, you have a witness that wants to give in a lay witness that wants to explain that the person that they observed was mad. So how do you say that? That's an opinion, right? If the person's mad, that's an opinion. That's your opinion of him, right? Are you an expert in psychology to be able to say that person was actually in a state where he was angry? I mean, so how are you supposed to do that as a lay witness? So, well, you have to say, well, his eyes were furrowed and his face was turning red and there was smoke coming out of his ears. I mean, come on, let's get real. So if the witness just wants to say just some basic impressions, some basic opinions that will just help to clarify what he's trying to say, so then we'll allow that type of opinion testimony in by a lay witness. So to say he appeared mad, he appeared disheveled, he appeared in a rush. So those are things that are allowed in by a lay witness. So some of the examples that the Connecticut courts have agreed a lay witness could give an opinion on is, for example, if let's say the owner of a property wants to say how much his house is worth, that he's allowed to give an opinion on. Another thing, the appearance of persons or things. The appearance of a person or the appearance of a thing. The speed of an automobile, that's something also we allowed, the Connecticut courts have allowed a lay witness to give an opinion about. The state of repair of a road. So these very basics which we all encounter, which we can all kind of say, yes, the road was in disrepair, that you're allowed to say. Okay, so that's just lay witnesses. So basically lay witnesses are only allowed to talk about facts, except some very, very basic opinions if it's just to help get out what they're trying to say. All right, so that's what lay witnesses are allowed to give. Now let's move on to 7-2. 7-2 in the Connecticut Rules of Evidence is testimony by experts. And this is what the rule states. A witness qualified as an expert by knowledge, skill, experience, training, education, or otherwise may testify in the form of an opinion. So here we go. Experts are allowed to give opinions. If the testimony will assist the trier of fact, so if the testimony will assist the jury in criminal cases, will assist the jury, or even in civil cases when you have a jury, but the trier of fact is generally who's the jury. If the testimony will assist the trier of fact in understanding the evidence, so what are we looking at here? How do we explain this without giving an opinion? If the expert is looking at something that's medical, how is he supposed to explain that to the jury without saying what his opinion about what he's looking at is? Is this a fracture or not? So the opinion, the doctor is saying his opinion about a fracture. Or especially when it gets into a little more technical medical terminology, then certainly it's going to help when the doctor has to give an opinion about what he's seeing, and that's going to help the jury. So that's number one, understanding the evidence, or in determining a fact in issue. So determining a fact, if it's going to help the jury determine a fact, was this a gunshot? Is this wound from a gunshot, or is it from something else? So if a medical examiner can say, yes, this is a gunshot wound, and that's an opinion, obviously, so then that's going to help the jury to determine a fact at issue in this case, whether this was a murder, a suicide, whatever it is. The point is that they know now that is a gunshot wound. So that is, again, that's something that an expert can give his opinion about. All right, so now that's the basic two different types of witnesses, lay witnesses and expert witnesses. So expert witnesses are certainly, the door is much more open for them to give opinion testimony. Now let's move on to the next category. The next category is an opinion on an ultimate issue. What's an ultimate issue? An ultimate issue is an issue that is given to the jury to decide. So the jury doesn't have to decide every single fact of the case, right? You don't have to go back to the jury room and say, was that a gunshot wound? How upset was he? How mad at Jennifer was he? they don't have to go through every single fact of the case. All they have to write down on that verdict form is guilty or not guilty, right? That's all they have to do. So an ultimate issue is simply, in this case, would be guilty or not guilty. That's an example of what an ultimate issue is. It's the issue that the jury has to decide for themselves. So, for example, whether this was, as we just explained. So now this gets a little nuanced. But let's just take it slow. So let's just read the rule first. We have section 7-3, general rule. Testimony in the form of an opinion is inadmissible if it embraces an ultimate issue to be decided by the trier of fact. So here, straight out, black and white, you're not allowed to give an opinion, no one's allowed to give an opinion, if it embraces an ultimate issue to be decided by the trier of fact, exactly as I just explained. Except, of course there's an exception, right? Except an expert witness may give an opinion that embraces an ultimate issue where the trier of fact needs expert assistance in deciding the issue. So, here you go. An expert witness is allowed to give his opinion about an ultimate issue if the trier of fact needs the expert assistance in deciding the issue. So here you go. Got a medical examiner. Medical examiner is saying that the manner of death is a homicide. They are saying that this was, if the ultimate question was this a murder was this a murder or a suicide? And the medical examiner gets up there and says, this was a murder. Well, that medical examiner is giving an opinion on the ultimate issue in that case, right? Because I kind of made it a little more simple as saying guilty or not guilty. But really, ultimately, if it's in that scenario where the question is, was this a suicide or a homicide or a murder, right? And the medical examiner is saying, this was a murder, that's my opinion, he is right, or she is straight out saying what the ultimate issue should be decided. That's what his opinion or her opinion is. So an expert witness is allowed to do that. That's what it says right here on the ultimate issue. But there is a small caveat, and that is where the trier of fact needs expert assistance in deciding the issue. Okay, so now we've gotten past those few rules. There's another rule that's very important, and that is also which came up in argument by the defense. And this goes by the next section, section 7-4. And this is also opinion testimony by experts. And the question here is what is the basis allowed to be for an expert to come to his opinion? What can he base his opinion on? And this goes to 7-4, subsection B. Basis of opinion testimony by experts. The facts in the particular case upon which an expert bases an opinion may be those perceived by or made known to the expert at or before the proceeding. So it could be based on facts which he or she perceived at or before the proceeding. So before trial, these were facts that the expert perceived or became known to the expert. Okay, so that's pretty straightforward, right? Some facts that he discovered or she discovered before the trial, or before coming to his opinion. Now listen to this part. The facts need not be admissible in evidence if of a type customarily relied on by experts in the particular field and forming opinions on the subject. So this is very important. Can an expert base his opinion on certain facts that are not admissible during trial? Is that allowed or not? And here it says, in the rule, straight out, that the expert is allowed to base his opinion on those facts, even though those facts themselves are not admissible in trial. However, those facts have to be facts that are customarily relied on by experts in the field. So he's not doing anything funny here, this expert, he or she. He's not doing anything funny here. They're relying on facts that are commonly relied on in this field, even though those facts technically are not admissible during trial. The facts relied on pursuant to this subsection are not substantive evidence unless otherwise admissible as such evidence. Okay. So that also needs some unpacking. So we're going to unpack it very simply. Okay, and this is what the case law in Connecticut has explained. The basis of opinion testimony by experts. The facts that an expert can rely on can be derived from one or more of three possible sources. All right, so you have one or more of three. So there's three possible sources. Number one, the expert's opinion may be based on facts perceived by the expert at or before trial. In other words, these are facts that the expert observed firsthand. Okay, we can all live with that. Second, the expert's opinion may be based on facts made known to the expert at trial. So if during the trial, the expert learned of certain facts while he was sitting in the gallery watching the trial, he is also allowed to then base his opinion on those facts that he learned. And then we get to the last part, which was the part that we may have some trouble digesting. And that is the part of where the expert is allowed to base his opinion on facts that are not admissible during trial. That's a little bit more harder to understand. How can we allow the expert to give an opinion based on facts, and those facts are not even admissible in trial? So listen to what the Connecticut courts have held in this specific situation. Although the factual basis for expert opinions resting on the first two sources of information, meaning facts that are first-hand observations by the expert, normally do not encounter obstacles to admissibility, case law is inconsistent with respect to the admissibility of expert opinion based on facts in the last category. So actually, that last category that we just said, where experts are allowed to base their opinions on facts that are not admissible during trial, is not so simple. It's not as simple as we just made it sound. It's not necessarily that the expert could do that. But in Connecticut, in accordance with the modern trend in Connecticut, subsection B, which is what we just read before, provides that an expert may offer an opinion based on facts that are not themselves admissible if those facts are of a type customarily relied on by experts in the particular field in forming their opinions. Facts of this nature may come from sources such as conversations, informal opinions, written reports, and data compilations. Whether these facts are of a type customarily relied on by experts in forming opinions is a preliminary question to be decided by the trial court. So, yes, in Connecticut, you are allowed to base your opinion, if you're an expert, on conversations that you've had, which is straight out hearsay, informal opinions, written reports, data compilations. So these things are allowed to be relied on by the expert, even though they're not admissible in trial, because they're customarily relied on. Now, one of the problems that you may have with that is the confrontation clause. And this is something that the defense actually argued in this case. He said that this is going to violate the Sixth Amendment rights of Michelle Troconis, because you have the right as a defendant under the Sixth Amendment to confront any testimony that is being given in a case. So I can't say that somebody told me testimony and use that information, that testimony that I heard outside of court, to convict Michelle Troconis without allowing her, or her attorney in this case, to confront that specific witness. Right? So as we explained in other videos, that statement has to be testimonial in nature. So if it's testimonial in nature, like a police report, something like that, so then she has a right under the Sixth Amendment to confront those police officers and have them come into court and testify. And we can't just rely on what the police officers told somebody. So you would think that this would be a Sixth Amendment problem. And this is what the courts have said about that. This is in Connecticut. Opinion based on information provided by others does not violate confrontation clauses if the expert is available for cross-examination concerning the nature and reasonableness of reliance. So, as long as the expert is there to confront him about his sources of information, that the Connecticut courts have ruled is okay. That's enough. You'll satisfy the confrontation clause by allowing cross-examination on the expert on his sources. So you can say, where did you hear this information from? Oh, from the police officer? That's where you heard this information from? And cross-examine him on that line. So that already that's a pretty big step, because you would think the confrontation clause should force that police officer to come into court. But the Connecticut courts have held that that's okay. You don't need to, as long as the expert is available to cross-examine him. So there we go. That is what the Connecticut, so even though this is maybe a little bit hard to swallow, that is what the Connecticut rules of evidence are. That you are allowed, an expert is allowed to give opinion testimony regarding facts that he learned or she learned, and those facts are not admissible in trial. So what do we have here? Now that we understand this, now with this backdrop, now we can understand what the argument is with the medical examiner. The medical examiner here did not do an autopsy, so he has no, or she has no first-hand observations. And therefore, the opinion of the medical examiner cannot be on that first or second prong of observations that the medical examiner made themselves. Now, of course, the medical examiner could have observed the clothing that Jennifer Dulas was wearing that had her DNA on it, and be able to talk about some of the blood that he saw there and things like that. That could be from his first-hand observations. But the argument here is that he's going to be relying on all of these police reports and some of these conversations with police officers. That goes into that second category, which is you're relying on facts that are not admissible. Well, according to the rules of evidence in Connecticut, it doesn't matter. It doesn't matter, because the expert is going to be available for cross-examination, and the rule says straight out, even though it's perhaps testimony, which is going to be an opinion about the ultimate issue. And again, why isn't it an ultimate issue? Because you'll hear the arguments about ultimate issue in this case also. The reason, I mean specifically today, the reason why they're arguing about ultimate issue is because an ultimate issue in this case is whether Jennifer Dulas was murdered. If Jennifer Dulas was not murdered in this case, then there's nothing to talk about with Michelle Troconis. So that is absolutely an ultimate issue in this case, whether Jennifer Dulas was murdered. So if the medical examiner is going to get on the stand and say an opinion and say that Jennifer Dulas, yes, was murdered, and that's what the medical examiner was going to say, because the state has to let the defense know that that's what the medical examiner is planning on saying, then that is an ultimate issue. But still, under the rules of evidence, it shouldn't be a problem. Technically, it should be no problem, because an expert is allowed to give opinion testimony even on an ultimate issue, and even using facts that are not admissible during trial. And this was a very big argument the defense was making, is that how can we allow the witness, this expert witness, to testify using these facts that are not admissible during trial? So they both quoted a case called State versus Barrios. And this is also where the judge eventually made his ruling based on. So it's important to know the facts of State versus Barreras. So let's get into a little bit about the holding and the facts of State versus Barreras. State versus Barreras was a case where somebody was hit by a car. A person was run over by a car. Question is, was it on purpose? Was it a murder? Or was it not? Was it a suicide? Was the person just stepping in front of a car? Or was it an accident? Those are the questions. And there was a medical examiner named Susan Williams. And Susan Williams initially conducted the autopsy, performed the autopsy. And she performed the autopsy on August 11th, 2014. That's when she conducted this, performed this autopsy of the victim. And on that date, when the medical examiner performed the autopsy, she listed the manner of death as circumstances pending further investigation. So she was not clear whether this was a suicide, an accident, or a murder. Then, on December 24th, 2014, she amended the manner of death to homicide. So all of a sudden, she learned of new things, and since she learned of new things, now she amended the manner of death to homicide. So she started off with, I don't know, not sure, and then a few months later, she decided, no, it's a homicide. So, the defendant contended that this amendment was based not on Williams' medical expertise, but on the completion of the police investigation. Since the police was continually investigating this crime, and it completed its investigation on December 24, 2014, and reported back to the medical examiner with their findings, now the medical examiner said, okay, now I can say that this was a homicide. So the defendant says, well, what changed? What changed from August 11th, 2014 to December 24th, 2014? She had the body, she performed the autopsy on August 11th, 2014, so she's using all of her medical expertise for that portion. Well, what changed? The only thing that can possibly have changed was the police are telling you what else they investigated in this case and why they believe it's a homicide. And now the medical examiner wants to amend her report and say, yeah, you're right, it's a homicide. Well, what's that based on? Is that based on medical knowledge? Is that based on medical expertise? Or is that just based on what the police are telling you? So this was the exact argument that the defendant made in this case, State versus Barreros. And therefore, the jury would not need her testimony on the manner of the victim's death, which was an ultimate issue in the case. So remember, let's go back to the rule of the ultimate issue on the case. Are we allowed to hear an opinion on the ultimate issue in the case? Well, as we said, generally speaking, it's inadmissible. But an expert is allowed to give an opinion which embraces, meaning gives you his opinion about the ultimate issue of the case. But there was a caveat where the trier of fact needs expert assistance in deciding the issue. Is this something that the jury needs expert assistance now? The expert assistance, this expertise already finished in August 11, 2014. And anything additional was just information that the police can testify about what they found. So, do we need a medical expert to give an opinion about the ultimate issue of a case where the opinion using all of our medical expertise was already finished in August 11, 2014, and now it's just, okay, well, the police did some more investigation, and therefore now the medical examiner is changing her opinion. But that's not based on medical knowledge or expertise or training. And therefore, the defendant in this case argued that the rule should revert back to that an opinion on ultimate issue may not be given, because the only time an expert is allowed to give an opinion on an ultimate issue if it's needed to assist the jury. And the jury doesn't need expert assistance at this point, because they already can have all the expert assistance that they could have handled from this medical examiner on August 11, 2014, and everything else they can supplement with whatever the police found the police can share during trial. That was the argument in this case. So let's see what the opinion, what the court held. Williams, this is again Williams, talking about, they're going through the case about Williams. Williams stated, she was the medical examiner in this case, that the information she received from the police investigation assisted with her decision to classify the manner of death as a homicide. Williams further explained that pathologists would consider the context of the events as obtained by the police to assist in the determination of the manner of death. And the court responded to the defendant's arguments that they are not persuaded. They're not persuaded by this whole argument that really this is not medical expert testimony anymore, and this is just information that the police are now supplementing, and they don't agree. And they say the following. Next, the facts and circumstances of the present case support a conclusion that Williams' determination of the victim's manner of death was based on her medical knowledge and expertise and not solely or primarily on the police reports. The defendant was arguing that the only way that she came to this conclusion was solely or primarily on the police reports. Williams conducted the autopsy of the victim on August 11, 2014. She documented the injuries suffered by the victim, including abrasions to the left side, and then they go through all of the injuries that she documented. It is clear, therefore, that Williams' ultimate conclusion as to the manner of death was not made solely or largely on the basis of the police reports, but rather on her medical knowledge, training, and experience. So in this case, the court held, hold on a minute. She did an autopsy. She has all this medical knowledge that she's using to assist her in her autopsy. And then after the autopsy, she gets this extra information from the police. And even though you're right, maybe that's considered hearsay, maybe it's not admissible in court, but it still assisted her in her determination using all of her medical knowledge and medical expertise that she already was able to use and everything that she learned from doing that autopsy on August 11th, 2014. And therefore, it would be admissible. It's not just solely based on this other reports, and therefore the defendant's arguments here that she should not be allowed to give an opinion on the ultimate issue was rejected. So, now let's apply it to our case, the Michelle Troconis case. Here, the judge said that there's no reason there. I'm sorry. The judge said over here that there's a clear distinction in this case. In the Michelle Troconis case, there was no autopsy performed. There was no autopsy. There was no body. So therefore, largely, the basis of the medical examiner's opinion would be based on the police reports and what she learned from the police. And one of the things the judge said is that the jury actually has more information than the medical examiner. After this trial is going to be done, they already heard from all the cell phone experts and all these experts that the medical examiner is very possible did not hear from. So the judge felt that this case, although this case came on the side that the medical examiner should be allowed to testify about the manner and cause of death based on some of the facts that she learned from the police department, from the police officers and the detectives, but in this case, in the Michelle Troconis case, there was not enough, according to this judge, there was not enough of the medical examiner's own expertise in the medical field to base the opinion that they're going to reach on an ultimate decision, which was that Jennifer Dulas was murdered. And even though technically you can argue, and I think this could have gone either way. I think that either way, I don't think there would have been an abuse of discretion, which is the standard of review if this issue would get appealed. It's an abuse of discretion. So I think this could have gone either way because the medical examiner did have her clothing and did have the blood on her clothing. So they did have some, the medical examiner did have some actual observations and investigation and observations that the expert did himself or herself. But the judge felt that that was not enough. And if there would have done an autopsy, then you're right, all this stuff would have come in. But because there's no autopsy done and there's no body, so most of the information is coming from these other sources, and all these other sources are going to be put onto the jury, and even more than that. And therefore, the judge felt that therefore there's no reason to allow the medical examiner to testify. And that's why, in this case, in Michelle Troconis' case, the medical examiner was not allowed to testify. All right, well, that does it for today. Now you can go back, watch that whole give and take between the attorneys, watch the judge's opinion, and now everything's going to become much more clear now. If you haven't yet, please subscribe, like the video, and we will see you next time.